In 2006, the Supreme Court decided that when public employees speak pursuant to their official duties, they are not protected by the First Amendment. If you are a faculty member at a public college or university, you may lose your right to speak up.
The Garcetti decision involved a California deputy district attorney, a man named Richard Ceballos. He complained to his supervisor and to the opposing counsel in a case that the deputy sheriff in that case had committed some misconduct. Ceballos submitted a memo. He said that something had happened wrong in the case. He wanted it to be revisited. He was ultimately demoted and transferred, and he sued, saying that that was because of these complaints that he had made and that violated his First Amendment rights, that he had a First Amendment right to speak about these issues. The case went up to the Supreme Court, and the court ended up saying that when public employees speak on matters pursuant to their official duties, that they're not protected by the First Amendment. So what that means is that their employer can demote them, can fire them, and that none of that is protected by the Constitution. The AAUP had recognized when this went to the Supreme Court that there could be some specific concerns related to faculty speech if the court came out the way that in fact it did. So we submitted a brief along with the Thomas Jefferson Center for the Protection of Free Expression flagging these issues. The court said, even though it was making this decision about public employees and about official duties, that it recognized that there might be different considerations for speech related to scholarship and teaching. And the court said that it wasn't deciding at that point if its analysis applied to speech related to scholarship or teaching. After Garcetti, there have been several cases that have come down that have really crystallized a concern about Garcetti itself.
3 recent federal court decisions have the effect of saying to state college and university professors, if you make a public statement or post something on a blog or write a letter that's controversial, that somebody, maybe the institution, the governing board doesn't like, and if you end up in federal court seeking reinstatement or some other form of redress, you're likely to be told that if your statement pertains in any way to your university role, even though it may not be your precise day job, then it is now unprotected as far as any First Amendment claim goes, because it's deemed to be within what the Supreme Court has defined as a public employee's official duties. The irony is that the scope of protection diminishes the closer one gets to one's area of expertise, so that the strongest claim for First Amendment protection by a state college or state university professor these days is something that is so remote from the field of expertise or doesn't even pertain to the person's university role at all, and thus, of course, is a statement of little consequence or credibility. That's ironically where the official duties doctrine has least reach and has the least effect in undermining or diluting First Amendment protection. So it really has produced a perverse and very worrisome as well as illogical situation.
What's unique about the faculty at a university is that they are, even though they are employed by the university, they really should not see themselves or be seen by others as employees in the ordinary sense. Faculty bring an expertise in their subject area and in the understanding of the university in general that is crucial to the integrity of higher education. That expertise applies to not only what they teach, but it also applies to academic programs, to the definitions of majors and minors, to graduation requirements, to the hiring of faculty, to the hiring of their colleagues, the evaluation of their colleagues. And in all these areas, there has to be frank and honest discussion, conversation, evaluation amongst those faculty and between the faculty and the administrators. The faculty set up such institutions as a senate or as committees to which they are appointed by other faculty committees or elected by their faculty peers to represent their interests. They elect representatives to the Board of Visitors who can convey their concerns and participate in dialogue with the governing boards. And in all of these ways, faculty behave in a way that's quite different from an employee in a corporation.
In the current climate, it seems to me almost any faculty participation that might entail a controversial statement or an outspoken view is potentially at risk. If the only time a state college or state university professor is really safe in terms of First Amendment protection is when talking about something that person is woefully uninformed about, has no expertise, couldn't possibly be deemed to be within that person's official duties, and that's basically where we are now, then it seems to me at least all useful types of faculty participation in university governance are potentially at risk, because a person will say, well, if I speak out, if I even present a committee report that has in it some statements that somebody's going to think are contentious or controversial, then I may find myself personally at risk, and I can't go to court and claim this was within my First Amendment protection if a court will ultimately say, no, this was part of your, quote, official duties, unquote, and for that reason it's unprotected. So I believe virtually all forms of faculty participation are potentially at risk under this doctrine.
I think it's a good question to ask why we specifically want to protect, both in the courts and in policy language, faculty involvement in shared governance, and not just what people might think of as the classic speech in the classroom, speech about research issues, things like that. I think the answer is that you simply can't have academic freedom without faculty involvement in shared governance, in institutional governance. One is connected to the other, and you can't separate them. Decisions about who's hired into a department are connected to decisions about what gets taught and how curriculum is developed, things like that. And to the extent that faculty members are chilled about discussing these issues of institutional governance, discussing hiring decisions, discussing budget decisions, they'll be chilled in other discussions as well, in the classroom, in discussions about research, things like that. There's simply no way to protect one without protecting the other. There are a number of steps that faculty can take to improve the climate on campus. We would really encourage faculty members and others to take a look at the report that's on the website, the executive summary. There are a number of materials available. The subcommittee report makes a number of recommendations. There are a number of action steps in terms of collaborations that faculty can make, allies to work with in terms of other faculty groups, administrators, other groups that are working with faculty or with issues in higher education, other groups working on issues of free speech, civil liberties, and groups working with public employees. If faculty members are going to think about the one thing that they can do, maybe the single most important step, I think we would encourage them to think about the policy language that's in a faculty handbook or in a contract on their campus. If there's no language about academic freedom, develop a policy. And if there's already language on academic freedom, we would encourage them to revisit it and ensure that the policy protects not just involvement in research, involvement in teaching, classroom speech, but also protects speech about matters in the community, matters that are important to the public, and matters about institutional governance and institutional decisions.